The trial chamber has examined all the parties' submissions in their written and oral form when determining the sentence for the crimes of which the accused has been found guilty. Bearing in mind that the accused will not be convicted for the crimes of his subordinates, but only for his failure to prevent them, the trial chamber underlines its belief that the sui generis nature of a superior responsibility pursuant to Article 7.3 of the statute allows for an even greater flexibility in the determination of sentence. Prosecution, referring to the gravity of the crimes as well as to the number of aggravating factors, requested that the accused be sentenced to 18 years imprisonment. The defense submitted that any punishment would be highly inappropriate. The trial chamber finds that the vulnerability of the victims is the only aggravating circumstance to be taken into consideration. However, a number of relevant mitigating circumstances have been taken into account. These are some cooperation with the prosecution, some expressions of remorse, the accused's express readiness to surrender to the tribunal if indicted, his young age at the time the crimes were committed, his family circumstances, acts of consideration towards Serb detainees, cooperation with S4, his general attitude towards the proceedings, and most importantly of all, the general circumstances prevailing in Srebrenica and those particular to the accused and to the crimes committed. All these are dealt with great detail in the judgment to which we refer you. This last mitigating factor, that is, the general circumstances prevailing in Srebrenica and those particular to the accused and to the crimes committed, is, in the firm belief of the trial chamber, the pivotal consideration for the purpose of establishing the appropriate sentence in this case. As described throughout the judgment, the conditions in Srebrenica during the relevant time were abysmal and deteriorated by the day. Militarily superior Serb forces had encircled Srebrenica, a threat to which the Bosnian Muslims in town were almost entirely unprepared. An unmanageable influx of refugees, critical shortages of food and other essentials, general chaos, and the flight from Srebrenica of all pre-war authorities resulted in a total breakdown of society in Srebrenica, including a collapse of law and order. These were the circumstances when, at age 25, without any relevant military and administrative experience, the accused found himself elected commander of voluntary fighters who were poorly trained, did not form part of a proper army, had very few weapons at their disposal, and were without an effective link to the Bosnia and Herzegovina army and Bosnia and Herzegovina authorities. It was a continuous uphill struggle that, in actual fact, achieved very few results. In addition, the accused had to rely on local leaders, some of whom not only chose to act independently, but even considered him inexperienced and scorned his authority. His situation became worse with the passage of time as the Bosnian Serb forces increased the momentum of the siege. As stated earlier, however, there was an interval of time in December 1992 and most of January 1993, during which the accused not only had the duty to prevent the reoccurrence of murder and cruel treatment of prisoners, but also was not in the impossibility of fulfilling it. Nor was he reasonably impeded from carrying out this responsibility. Still, it is the conviction of the trial chamber that he preferred to do nothing, notwithstanding that he could have prevented the reoccurrence of these crimes. This is the only wrongdoing he has been found guilty of. However, the trial chamber understands that although his predicament at this time was not as bad and perilous as it was during the ensuing Serb winter offensive, it still was one which should have a strong mitigating effect in the assessment of the sentence to be inflicted against him. The trial chamber is finding the accused guilty, and will be sentencing him because he had reason to know that the reoccurrence of murder and cruel treatment of prisoners was possible, and because he decided not to do anything about it, not even to at least try and inquire about the situation of prisoners. There is no other case in this tribunal, and there has not been any other case in this tribunal in which the accused was found guilty of having failed to prevent murder and cruel treatment of prisoners in such a limited manner and in such abysmal personal and circumstantial conditions as in this case. Consequently, the sentence that is being meted out reflects this uniquely limited criminal responsibility. However, the trial chamber emphasizes the fact that the leniency of the sentence, which we will very shortly impose on the accused, does not and should not diminish from the principle that the trial chamber has endeavored to articulate in its judgment, namely, that for the purpose of Article 7.3 criminal responsibility, commanders should throughout maintain awareness of the imperativeness required to be given to the protection of prisoners in times of conflict. Finally, the trial chamber wishes to state that all the conclusions reached in this judgment, legal and factual, including the sentence itself, were arrived at unanimously. This position, Mr. Orić, would you please stand up? For the reasons summarized above, this trial chamber, having considered all of the evidence and the arguments of the parties, the statute and the rules, and basing itself on the factual and legal findings as determined in the judgment, decides as follows. You are found not guilty and therefore acquitted of, under count 1, failure to discharge your duty as a superior to take necessary and reasonable measures to prevent the occurrence of murder from 24 September 1992 to 16 October 1992, pursuant to Articles 3 and 7.3 of the statute, and failure to discharge your duty as a superior to take necessary and reasonable measures to punish the occurrence of murder from the 27th December, from the 24th September 1992 to 16th October 1992, and from the 27th December to 20th March 1993, pursuant to Article 3 and 7.3 of the statute. Under count 2, failure to discharge your duty as a superior to take necessary and reasonable measures to prevent the occurrence of cruel treatment from 24th September 1992 to 16th October 1992, pursuant to Articles 3 and 7.3 of the statute, and failure to discharge your duty as a superior to take necessary and reasonable measures to punish the occurrence of cruel treatment from 27th December to 20th March 1993, pursuant to Articles 3 and 7.3 of the statute. You are, however, found guilty of, under count 1, failure to discharge your duty as a superior to take necessary and reasonable measures to prevent the occurrence of murder from 27th December 1992 to 20th March 1993, pursuant to Article 3 and 7.3 of the statute. Under count 2, you are found guilty of having failure to discharge your duty as a superior to take necessary and reasonable measures to prevent the occurrence of cruel treatment from 27 December 1992 to 20th March 1993, pursuant to Articles 3 and 7.3 of the statute. Lastly, you are found not guilty and therefore acquitted of the following counts. Count 3, failure to discharge your duty as a superior to take necessary and reasonable measures to prevent or punish the occurrence of acts of wanton destruction of cities, towns or villages not justified by military necessity, pursuant to Article 3 and 7.3 of the statute. Count 5, wanton destruction of cities, towns or villages not justified by military necessity pursuant to Article 3b and 7.1 of the statute. We sentence you, Nasser Orić, to 2 years of imprisonment. According to the law of this tribunal, you are entitled to credit for the period of time you have been in custody towards the sentence which we are meting out. You were arrested on the 10th April 2003, therefore you have been in custody for 3 years, 2 months and 21 days. Since the imposed sentence is less than the credit to be applied for the period of time you have been in custody, the trial chamber orders that you be released immediately from the United Nations detention unit after the necessary practical arrangements have been made. Thank you.
All rise. Wyjevuleve.